Let's start with Marjorie Taylor Green winning her lawsuit or winning her challenges. So what was the latest court development in that?
So the way that worked was the way it works in Georgia is you can file an election contest prior to an election about someone being on the ballot. Any citizen can do so. That citizen filed such an election challenge. Marjorie Taylor Green then sued in federal court on the grounds that such a challenge should not be allowed to occur because it violates various constitutional provisions, including her own First Amendment rights of freedom of speech, but also the Constitution delegates exclusively to Congress the qualification of its members. And the court, she got a liberal judge, and the liberal judge dodged it. So what happened and didn't intervene? That returned it to initially an administrative law judge who conducts a hearing if he so chooses, and then issues an advisory opinion that then goes to the elected Secretary of State, who either affirms or rejects that advisory opinion in determining ultimate ballot status. The administrative law judge conducted a full trial. I thought it was kind of a little crazy, but Marjorie Taylor Green took the stand. And that's where the media tried to make it, and some of the advocates in that proceeding tried to make it that even saying 1776 was somehow a criminal insurrectionary act. For those that don't remember, the 14th Amendment was passed after the Civil War to basically prevent people who left elected office, who had taken an oath to the United States and left it to join and support the Confederacy, to prevent them from having future federal office. But it delegated to Congress the enforcement of that provision. Congress ultimately chose to amnesty everybody about 7 years later, passed another amnesty 20 years after that, that basically made it clear that they were not going to enforce that provision. It was momentarily resurrected during World War I to keep Victor Berger, try to keep him out of Congress because he was a Democrat, actually a socialist from Milwaukee who was against the war. Milwaukee also had a very big German-American population, and Germany was the focus of the other side of that war. So there are multiple reasons. Of course, World War I was built on a lie, but you can go to the hush-hushes at vivabarneslaw.locals.com about that false flag. But it was misapplied in my view, and it has been dead pretty much since then. And Mark Elias and the Democratic lawyers, the same people as we'll bridge into later discussing 2000 Mules, were heavily involved in changing the legal rules for the election last time, but not in a legal manner, came up with the idea of let's use the 14th Amendment to kick all the populists we don't like out of Congress, to keep them from even being chosen by the voters to represent them in Congress. So they've tried this first with Madison Cawthorn. A federal court said that was a nonsensical interpretation of the 14th Amendment's application, especially given the amnesty statutes that were subsequently passed, and said that they cannot prohibit Madison Cawthorn from being on the ballot. Then it went to challenging Paul Gosar in Arizona, another strong populist advocate, about election reform in particular, as was Madison Cawthorn. And he, too, the court said, no, you cannot keep him off the ballot based on this kind of lunatic interpretation of the 14th Amendment. Marjorie Taylor Green went through the process, went through a hearing. The administrative law judge wrote the opinion that we predicted the administrative law judge would write, which was that, no, they haven't met their standard for saying that somehow the 14th Amendment prevents Marjorie Taylor Green from being elected to Congress. The Secretary of State's almost guaranteed to agree with that, even though the Secretary of State is Ratberger, who should lose his reelection bid, who was not helpful, as the 2000 Mules movie helps document and demonstrate indirectly by what he failed to do in both the presidential election and the Senate runoff. But he's not going to go against the administrative law judge's ruling, a federal judge's ruling in an analogous case, and a state court judge's ruling in another analogous case. So Marjorie Taylor Green will be on the ballot. Madison Cawthorn will be on the ballot. Paul Gosar will be on the ballot. And hopefully this will start to put the nails in the coffin of this dangerous, derelict theory of Mark Elias's and prevent it from being used against President Trump or anyone else in the future.
Because there was that administrative thing, which some people didn't understand, is that the administrative contestation where the judge was hearing it and seemed favorable to Marjorie Taylor Green, his decision was never final regardless. He issues his ruling or his finding, submits it to Raffensperger, who then has the final say. But she had also filed the same motion to dismiss on the merits, which I still don't fully understand, but invoking the constitutional exception, which had been granted to Cawthorn, but not to Marjorie Taylor Green. So ultimately, the judge in the court of law said, you benefit from the same exemption?
I mean, effectively, but he did a long analysis that said, however it's calculated, they have not met their burden to show that she engaged in criminal insurrection anyway. So that it didn't matter whether you measured whether she was exempt because of the First Amendment, exempt because only Congress determines its qualifications, exempt because of the amnesty law provision, exempt because Congress has never passed any enforcement mechanisms of this rule, as other judges have commented upon. Even if you ignore all four of those, when you get to the fifth matter, did she engage in criminal insurrection? Of course not. It's utterly ludicrous.
It was preposterous. I mean, even the evidence, and what evidence was adduced in the real courts versus the administrative courts? Because, like, look, we saw her.
No evidence was really introduced into the federal court because it was done at a motion to dismiss stage, which assumed all facts as true.
Okay.
No evidentiary hearing was conducted or discovery allowed. Instead, the only discovery and evidentiary hearing was conducted by the administrative law judge, basically a bureaucrat. I don't know why they call him judge, but that's an old grievance of mine. It's like calling ex-judges that are arbitrators judge. It's like, you're not a judge, you're an arbitrator. Quit calling yourself a judge. Just because you once were doesn't mean you are now. But in civil discourse, you can recognize someone as judge. I get who was used to be a judge, but they're putting them in arbitrator or an administrative law judge, calling them as a judge, creates this misapprehension that they have the power of the judicial branch, and they do not. And that's my problem with it. So it's an attempt by the bureaucratic clerical class to recreate all power within the administrative state of the executive branch without political controls. That's what it really is. But either way, the ALJ, to his credit, made the sensible decision that under any analysis, they did not meet their burden of proof at all or anywhere close to it, that Marjorie Taylor Green engaged in any kind of illicit insurrection. It's not like there were a bunch of people outside of a Supreme Court justice's house demanding he change his opinion on a coming case. You're on mute.
I'm an idiot. I had an extra word for my own self there. We're going to get there in a few minutes.